In this Contract Law eBite on the fundamentals of English contract law, we explain how contracts are formed and how contracts can be varied. A contract sets out the rights and responsibilities of each party to that contract. 5 basic elements must be satisfied in order to create a contract. They are 1. An offer. This is a promise by one party to enter into a contract on certain terms. 2. Acceptance of that offer. The other party must accept the offer in full for a binding contract to be formed. The acceptance has to be communicated to the party who made the offer. 3. Consideration. This is the exchange of something of value. It has to be reciprocal. At a very basic level, Mr. Smith offers to sell Mr. Jones 10 pens at £1 each, and in consideration, Mr. Jones pays Mr. Smith the sum of £10. 4. An intention to create legal relations. The parties must have intended to enter into a legally binding contract. This intention is presumed in the case of commercial parties, but can be rebutted if a party can show that they did not intend to enter into legal relations because, for example, there were outstanding matters to resolve before the contract was entered into. And finally, 5. Certainty of terms. There must be agreement by the parties on all material terms, and the terms of the contract must be clear. Most of the time, we think of contracts as written documents, but that isn't always the case. The elements needed to create a binding contract can be satisfied quite informally. For example, a contract can be formed orally during a face-to-face conversation or a telephone call. A contract can also be formed during an exchange of emails and even by the behaviour of the parties. Some contracts, such as a contract for the sale of land, are required by law to be made in writing. In a business context, it is recommended that contracts are recorded in writing. A written contract offers the best legal protection to the parties. If parties are doing business on standard terms and conditions, they need to take care to make sure that their standard terms of business are properly incorporated into the contract. Where both parties are trying to rely on their own standard terms of business, then something called the Battle of the Forms can arise. Our eBites Plus module on the fundamentals of English contract law will tell you more about the Battle of the Forms and the steps you can take to either win or avoid the Battle of the Forms. Imagine that you have been selling services to a customer based in the UK for a number of years. You have a very short contract in place which sets out the scope of the services, the price, and a few other key legal terms. The business relationship is going well, but you now want to add some other services to the scope, and also you need to put your prices up. Your customer has broadly agreed to the changes, but how do you make sure that this is done correctly? Ensuring that any contract variations are in writing and follow an agreed process provides certainty to both parties and avoids an informal discussion binding the parties, to which there's no record and the parties may disagree as to what was actually discussed and agreed. In order to be valid, a variation to a contract will need to satisfy all 5 elements needed to create a binding contract that we looked at earlier. In particular, you will need to think about whether there is consideration for the variation. This short overview of the fundamentals of English contract law highlights why it is so important to get the basics right whenever you are entering into a contract or amending an existing contract. Our eBites Plus module on the fundamentals of English contract law will tell you more about these topics and improve your understanding of them. This eBite is based on the law of England and Wales and is provided for general information only. It is not a substitute for legal advice. Please get in touch if you would like to know more or to upgrade your subscription to access WBD eBites Plus content.